So our organization provides free civil legal services to eligible low-income individuals in North and West Texas. So that means we help people with a variety of legal issues. So we help people with family law matters, with protective orders, divorces, child custody matters, and child support matters. We also help people with estate planning, end-of-life planning. We also do a lot of help with foreclosure prevention and other housing-related issues, which is especially important during COVID-19. We help with landlord-tenant disputes, federal housing issues, reasonable accommodations, and those kinds of things. And also, of course, we help with consumer protection, which is why everyone is here this evening. So there are some things that our organization cannot provide assistance with. We can't provide help with medical malpractice claims, class action lawsuits. We don't help with assisted suicide or abortion-related litigation. We also can't provide assistance in personal injury cases. We also can't provide any representation in criminal law matters. I will say, as a small caveat to this, we do help people seal eligible criminal records or expunge eligible criminal records. That's not so much a matter of criminal law as it is an administrative thing, but we do help people with those kinds of issues as well. So whenever we talk about eligibility for our services, we're talking about the people that our organization is trying to serve and the needs we're trying to meet. So in order to receive services through our organization, you have to be income eligible, you have to be asset eligible, you also have to be a United States citizen, or you have to have another qualifying legal status, and you have to have a legal problem that we can help you with. So what does it mean to be income eligible? So very broadly, an individual who is eligible for our services is at or below 200% of the federal poverty guidelines. An example to kind of help visualize this is a family of four would have an annual household income of about $52,000. This isn't something that I think people need to be terribly concerned with bogging themselves down with. You don't need to pull out your tax returns and crunch numbers. But there is a really helpful resource available on our website. If you go to our website, you can see the eligibility guidelines that we use for people. So if you ever have a question about whether your income fits within our guidelines, you can go and check for yourself. I would also encourage anyone that does want to apply for services who think they, might not be income eligible to contact us anyway, because there are a lot of factors that we consider whenever we qualify someone for legal services. To be asset eligible is similar to being income eligible. So someone seeking legal assistance from us can't have a total family assets in excess of $10,000, an additional $5,000 for each family member. Like I said, there's a lot of factors that we consider when we qualify people for our services. So if you have questions, I would encourage you to call us and ask us anyway. But basically, we just want to make sure that people who are receiving our services are the ones that deserve it. So someone doesn't have $1 million or $500,000 sitting in a 401k when they could, afford to get an attorney. Eligibility and citizenship. So to be eligible for our services, you have to be a U.S. citizen, or you have to have another legal status to be in the country, permanent residency, refugee, asylee. One exception to the rule that we do have for this is if you're not a citizen and you don't have a legal status, we can provide legal assistance if the person is a victim of domestic violence, and we can help them with matters related to that domestic violence issue. So some examples of priorities or areas that we help people with include kind of this large laundry list. And there's other things, of course, that aren't included on here because we can help people with a wide variety of legal issues. And I'm sure Dominic will touch upon, consumer and finance tonight with predatory lending, deceptive trade practices. We also help people with special education needs and access to resources, I've already, mentioned that we help people with family law matters. Over half of all applications to our organization or for a family law matter, so a lot of people seek assistance with that. We also help people with housing, which I would encourage everyone to keep in mind, especially with the COVID-19, stays being lifted and things moving forward. Please keep us in mind if you need help. We help people with Medicare, Medicaid, and we also help people maintain their income, whether that's maintaining benefits, Social Security, or helping people with disability appeals, things that, help people stay with their income. So very briefly, I think it's good to go over our application process so people aren't confused. So what happens is that someone, contacts our office or one of the other application or points that people can go through, and we'll screen them for eligibility and we'll screen them for a conflict of interest just to make sure that maybe the other party in the legal matter hasn't contacted us in the past about the same thing or in the present about the same thing. And then we do an intake interview with the person so we can understand more about the facts of the matter and sort of the conclusion that the person is hopeful to have. And then all of our cases are reviewed by a panel of our staff attorneys and our managing attorney. They look at every single case, they consider all of our resources, our priorities, and if we would be able to help this person. Because of the large demands of our organization, because there is a large volume of applicants, we aren't able to provide full representation in every case as much as we would love to and as much as we try to. But we always try and provide some meaningful level of service for people, whether that be really good legal advice, preparing pleadings with directions, providing self-help materials, anything that we can do if we aren't able to provide full representation so people aren't left hanging or in a lurch. So in response to COVID-19, we've obviously had to make some changes. So all of our offices are temporarily closed to the public until at least June 12th. All of our clinics and in-person intakes and events, like we're doing this evening, have obviously been moved virtually or canceled. But I would like to highlight that even though we're not physically in our offices, we are still here to help people apply for services. There are a lot of ways that you can contact us and apply. You can go online to our website and do an application. I've also included the phone number for our Denton office here. You can call us and leave a message and we'll follow up with you with an application. We'll also extend the legal aid line. This is a great resource, especially if maybe internet connection is spotty. You can call this number and these listed hours. They have extended hours on Mondays and Wednesdays. They are closed from 12 to 1 for lunch, but this is a hotline that is staffed by attorneys. So in addition to taking application information, they can provide some brief legal advice to you when you call as well. So if you have a question that maybe you need answered right away, this is a good resource to take advantage of. So we also have other COVID-19 resources that I would encourage anyone who has questions to go look at. All of these are free and available to you. We have a whole page on our website dedicated to COVID-19 resources. We also have a YouTube channel with a lot of helpful videos. You actually might see Dominic in a couple of them that cover consumer protections, which of course we're going to go into more detail this evening. But it also goes into the CARE Act, unemployment issues, housing issues, co-parenting and family violence, evictions, and just other important, things that have come out of COVID-19 that it is good to just know more about. So our office typically conducts in-person intakes, like I sort of touched upon a couple slides ago, but we've obviously had to cancel them. So to replace them, we've been doing virtual legal clinics. So how it works is that, someone can call our office and they can just leave a brief detailed message with a good way to contact them, good phone number. We'll follow up with them and do an application and get them registered for the clinic. And then on the day of the clinic, attorneys are going to call everyone who's registered and provide a free 30-minute legal consultation. It is free. They'll talk to you for 30 minutes, answer as many questions as they can. Applicants have to be financially eligible for free legal assistance, as I've already talked about. And these are just some upcoming clinic dates that we have. The next one for Wise County is going to be July 2nd. We have an upcoming one for Denton County on Monday, and then Cook County is at the end of the month. So even though these clinics do exist, and I would urge you to take advantage of them because they are a great resource, you can also apply for our services any other time through any of the other ways that I've highlighted. So just don't think that if you miss one of these dates, you've missed an opportunity to meet with someone or to talk to someone about your problem. So thank you so much. I really appreciate your time, and I'm going to sign off and pass it along.
Hi, everybody. I'm Dominic Robato. I'm a staff attorney with the Denton office of Legal Aid. I'm going to be talking with you today about consumer protection, specifically while we're dealing with this coronavirus pandemic. And I'm going to try and make some time for questions. If you guys have any questions, feel free to toss them in the chat. We'll be watching that as we go, and Emily will be asking me some of those questions as we go through this presentation, if we get any, so that we can help you guys out. So the first thing I'm going to be talking about today is debt collection. And I'm going to specifically be talking about situations where you might be currently being sued by a debt collector. But even just in your interactions with debt collectors, if you have something that's just a little bit past due and they haven't actually filed a lawsuit yet, then this is still going to be relevant to you. We're also going to be talking about some other consumer topics in this presentation, but I'm going to start off by talking about debt collection because, as I'm going to say, this is a very prevalent issue in Texas. In Texas, 44% of people currently have at least one type of debt in collections, at least one, credit card debt, student loan, medical bill that's actually in collections. Nationally, that is only about 33%, about a third of people have at least one debt in collections. So we're significantly above the national average, which is the big thing I wanted to highlight. And to put this in a different perspective, this is Texas here on the far left. You can see we're at that 44%. And all of these different blue lines, that's all the other states in the country. There's only one state that has a higher percentage of people with debts in collections than Texas. So definitely the big thing I want you to take from this is that, it's not that unusual to have a debt in collections. Nearly half of people in Texas have at least one thing that they've fallen behind on. So it's really not that unusual. It's nothing to be ashamed about. It's something that happens with most everybody. So the first question you have to ask yourself when you do get that call from somebody trying to collect a debt is, who are you actually talking to? You could be talking to the original creditor. This is the person who actually gave you money. So somebody like Capital One. You could also be talking with a third-party debt collector. So this is a company that is hired by the original creditor to try and get that money from you. Sometimes this is referred to as a law firm. They might call themselves lawyers or law firms. This might be the group that's actually filing the lawsuit. So, one popular debt collection law firm we have that we see a lot in Texas is Ross Sturm. So this is a company, the debt is still owned by, Capital One, but now this is a company that's been hired by Capital One to try and get that money from you to pay that debt. The third group we have is debt buyers. Now, a lot of people get confused between third-party debt collector and a debt buyer. The difference is that the debt buyer has actually purchased that past due debt from the original creditor. Now, this is a group, one of the big debt buyers is Midland Funding. The reason that all of this is relevant is what protections you have as a consumer depend on who you're talking to. If you're talking to a third-party debt collector or a debt buyer, a law called the Fair Debt Collection Practices Act, or the FDCPA, is going to apply. And you have all the protections of that law in all of your interactions with that debt collector or that debt buyer. If you're talking with the original creditor, you do not have those protections. That's not saying they can do whatever they want. We have similar protections in the state of Texas, but in terms of federal law, the Fair Debt Collection Practices Act is only going to apply if you're talking to somebody from one of these two types of companies. So let's step back a little bit and let's look at the timeline of what actually happens as each day goes by when you fall behind on a credit card. So at one day, and not even one day, at 1 minute past due, you have breached your contract with that credit card company, and now they can charge you those late fees, they can charge you that penalty APR. And a lot of people forget that that penalty APR exists, and they're surprised. The penalty APR is a major problem for consumers because it's very persistent. What happens is when you fall behind on a debt, a credit card company often has a higher interest rate that they can begin charging you on your account from the day that you go late on. That means even if you pay the late fees, you get caught up on it, that company might still be charging you that higher interest rate. And when I talk about a higher interest rate, it can be significant. Your interest rate could go from 10 to 15% all the way up to 25, 30% interest on that credit card. And you could be paying hundreds and hundreds of dollars every couple of months or every year in additional interest on your account because of that one time that you fell past due. I'll tell you that many companies will get rid of the penalty APR if you call and talk with them. So if you even just fall behind on your debts by a day or two, it's a great idea to get in touch with them, see if they're charging you that penalty APR, and ask that it be waived and that they move you back to your regular interest rate. If you're 30 days past due, that's usually when we're going to start to get some credit reporting happening. So at this point, you've gotten a past due statement from the credit card company. You didn't pay that statement in time, and now you're getting your second billing statement that says that you owe them that past due balance. That's usually when we're going to see your credit report actually get the notification that your past due is at 30 to 60 days. At 6 months, so you haven't paid the bill in 6 months, that's when we're going to see your credit card get charged off and possibly sent to like a third-party debt collection company or entirely have the debt sold off to a debt buyer. When your account is charged off, you no longer have an account with Capital One or with whoever that creditor might be. It does not mean that they have forgiven the debt. There's a lot of confusion about this because what will usually happen is you'll get a billing statement that says that they've charged off your account, and it will show that you owe a $0 balance. That's because they've closed your account and you no longer have a credit account with them, and they've moved your balance over to just a past due debt. So you still owe the money to them if it was charged off, but this just means that they've closed your account and that they're no longer going to keep extending you credit on that credit card. At 4 years, this is the next big thing that's going to happen with your account, is 4 years after the last time you used that card or you made a payment on that card, the statute of limitations expires. That means they can no longer file a lawsuit against you to try and collect that debt. And finally, at about 7 years after that charge-off date, that's when you're no longer going to see this on your credit report. If there is that negative history, then after 7 years, they remove that account from your credit report completely. If it doesn't have any negative history, accounts usually stay on for 10 years. but you do get it off a few years earlier if it has a negative history on it. So this is just a rough timeline. It'll vary a little bit from person to person and company to company, but it's a rough timeline of what to expect when you do fall behind on your bills. The most important thing to highlight is that 4-year mark, because if they haven't filed a lawsuit by that 4-year mark, they can never file a lawsuit against you for this debt. So a lot of people want to negotiate with the other side when they have a credit card debt that's fallen past due and it's gotten charged off. They want to negotiate with the debt collector and set up a payment plan. So here's some questions to think about before you actually negotiate with a debt collector or a debt buyer or even the original creditor. First off, can you afford to settle? And this is such an important question because if you can't continue to make those monthly payments, then you're just going to put yourself in a worse situation by setting up an agreement. Setting up an agreement, number one, can restart that statute of limitations that we talked about a minute ago. So now they could have a whole other 4-year period to be able to sue you. And if you actually make a payment under that settlement negotiation you've set up, under that payment plan, that will definitely reset that statute of limitations because it is 4 years from the last payment. So that means if they call you up and at 3 years and 11 months, they get you to set up a payment plan where you pay $10 a month and you make a $10 payment, and then the next month you can't afford it, they have another 4 years to file a lawsuit against you. What other debts do you have that might go into collections? Is this the most important debt that you have to pay? Is this past due credit card debt that's maybe 3 years old more important than the past due medical debt that you might have coming up, or the student loan that you're afraid is going to go into collections? There's some other things that might be more important, and that goes back into, can you afford to do this? Do you have rent that's past due? Do you have difficulty paying your rent every month? Are there other things that should take a priority? Have they filed a lawsuit? Are there other debts that have already filed a lawsuit that they have that judgment against you? Is this a company that's ever going to file a lawsuit against you? Can they file a lawsuit? Has the statute of limitations expired? Is bankruptcy a better option? And we'll talk more about this later, but that's something definitely to consider is, should you be looking at declaring bankruptcy? I've seen people who set up these settlement agreements and they're making payments every month, and then down the road they decide they wanted to declare bankruptcy, and all of that money they've been giving that company every month, they could have just done that bankruptcy earlier and not made all of those monthly payments. Is your income reliable enough to make these payments? If you work in a position that's seasonal, you have to take that into consideration when you're setting up a payment plan. Because maybe right now you can afford it, but if it's seasonal, maybe in 3-4 months, you're going to have difficulty paying it. And then what type of a settlement do you want to request? So there's 2 major types. You can set up a payment plan with most companies where you pay a small amount every month for a long period of time. And many companies are also willing to discount the balance that you owe them if you'll pay it all at once or in fewer monthly payments. So if you owe a company $1,000, they might accept $500 or $600 if you give it to them all at once, or they might accept $50 for a year rather than $10 a month for the next few years. And do you actually owe how much as they say that you owe? It's always important to make sure that the debt they have is valid and that there's not a dispute over the amount of the debt before you send them your hard-earned money. When you're speaking to a debt collector, first and foremost, don't tell them your story of how you owe the debt and why you weren't able to pay your bill. I honestly haven't seen a situation where a debt collector has been at all impacted by the story of how you weren't able to pay the bill or why. There's very few exceptions to that. The only exception is maybe if there was a medical situation that caused you to have difficulties, they may be a little sympathetic to that in certain circumstances. But for the most part, you don't owe the debt collector an explanation of why you couldn't afford to pay this debt. And all you're really doing is giving them that nice recorded conversation, explaining that you do definitely owe this money. Stay firm to what you're comfortable repaying every month. Don't let them bully you into spending an extra $10, $15. If you can afford to spend $15 a month, tell them you can afford to spend 10 and let them negotiate your way up to 15, because whatever you initially promised them is probably not going to be enough. They're probably going to want just a few more dollars out of you. So don't give them the absolute maximum you can afford to pay every month as your first offer. Don't speak to a debt collector at all if you can't afford to settle or enter into a settlement agreement. Nothing good comes from talking with debt collectors if you don't have to. What I recommend instead is sending them a no contact letter. You have the right under the Fair Debt Collection Practices Act to send the debt collector or the third-party debt buyer a letter by mail that says, I don't want to be contacted anymore, and they cannot contact you until they're ready to do something specific on your account, like file a lawsuit. Never agree to a repayment plan unless you know you can afford it every single month and you know that you will not be late. And this is especially true if they filed a lawsuit against you. Typically, if they filed a lawsuit against you, they're going to have to agree to the full judgment amount. And then if you fall behind on your repayment plan that you've set up, they'll be able to collect that entire judgment against you immediately. So it's very important. And I've said this a few times now, but it's very important that you never agree to a payment plan with a credit card company or a debt collection company that you can't afford to reliably pay every month on time. And don't make any payments until the debt collector has sent you the terms of the agreement in writing. It is not unheard of that a debt collector will set up a settlement agreement and will never send it to you in writing. And when you believe you've actually paid off the entire account, it turns out that they don't have a record of that settlement agreement and they still want another $1,000 or something. So make sure you have the exact terms of the agreement, including when your account will be paid off if you continue to make those payments. So if you owe $1,000 and you're paying $10 a month, you should have a piece of paper from them that says after $110 payments, the debt will be forgiven. Here's some of the rules that debt collectors have when they're talking to you under the Fair Debt Collection Practices Act. So they can call you from 8 a.m. to 9 p.m. your local time. They cannot call you outside of those times, though. So if you do get a call from a debt collector past 9 p.m. and before 8 a.m. your time, then you can file a lawsuit under the Fair Debt Collection Practices Act, and you should contact an attorney about that. They cannot call you at a time or a place which they know to be inconvenient to you. How do they know it's inconvenient? Well, because you've told them it is. So if you've told them, please don't call me at work, they can't call you while you're at work. They can call a third party, so one of your friends or even your boss at work. However, they can only do this to locate you, which means that they need to have not spoken to you. They need to not know how to contact you. If they've contacted you before and they've spoken with you, then they have no reason to say that they need to contact a third party. They can also do it with your express permission if it's a situation where you want them to speak to your wife or you want them to speak to your husband, whatever it may be. And they cannot identify themselves as a debt collector to a third party or reveal any personal information about you. So if they do call your boss to try and get location information, basically all they can say is that they have a matter to discuss with you and they want to know if that person knows how to contact you. Generally speaking, those phone calls are not successful if they follow those rules. So if one of your friends did speak to a debt collector, you should ask that person if they gave away your personal information or if they told them that they're a debt collector, because all of those things are violations of the law and you can get damages. So I talked earlier about sending them a please don't contact me letter. So let me talk a little bit about that. So debt collectors, like I said, they can't continue to contact you if you send them a letter that says not to contact me. The exceptions to this are if they're going to take a specific action, like filing a lawsuit or serving you with the documents for that lawsuit. You should send your letter to them by certified mail. Certified mail or registered mail is a way to track that they actually have received it, and you can actually get back a return receipt from the post office with their signature to prove that they received that letter. You should keep a copy of the letter that you sent them, and you should keep that proof of mailing the letter. That way, when they contact you in a month or 2 months about the debt to try and collect it again, you have evidence that you have sent them a letter by certified mail that tells them not to contact you. And it must be in writing. Now, you can communicate orally that some specific form of communication is inconvenient to you. Like you can tell them over the phone, don't contact me at work. But if you're sending a proper cease and desist letter under the Fair Debt Collection Practices Act, it needs to be in writing. Here's some other things that debt collectors cannot do when they're interacting with you. They can't lie to you or mislead you into paying the debt. They can't swear at you. They can't threaten to do things to you that they can't do or that they won't do. Debt collectors cannot send you to prison for not paying a debt. If they say you're going to be arrested, if they say you're going to go to jail, that's a lie. That's something that you can sue them for making those threats, even if you knew better and you weren't fooled. And we'll talk about that in a second. They also probably cannot take your house from you if you're getting threats like that, unless it's, of course, your mortgage company, and they do have a right to foreclosure, then they can't take your house from you, and certainly not before they've gone to court on the matter. It doesn't prevent them from doing things that they could legally do and that they actually intend to do. So your mortgage company may very well call you up and say, we're going to foreclose on your house if you don't pay this past due debt. But they have to have that right to foreclose on your house, and they have to actually intend to foreclose on your house if you don't pay it. And they also, they can't repeatedly call you or call you just to harass or annoy you. We see this a lot where people are getting calls, 30, 40 times a day, and you've spoken with them. There's no justification for that. If you're getting repeated calls from the same company, or if they're calling it, outside the times they should be calling, or they're doing anything to just harass or annoy you, then you should speak with an attorney about that. Like I said, if they've done any of this stuff that they shouldn't be doing, you should speak to an attorney. You can get any actual damages. So if you paid them money because they forced you to, or they did something that they shouldn't have done, you can get that money back. You can also get up to $1,000. So even if you really weren't harmed by what they did, if they called you at 11 o'clock at night and you didn't suffer anything as a result, you can still get up to $1,000 in what's called statutory damages. That's an amount that the court orders them to pay to kind of punish them and discourage them from continuing to do this stuff. And you can also get your attorney's fees. Now, of course, we at Legal Aid of Northwest Texas, we don't charge our clients any legal fees if we represent you and if you're eligible for our services. However, if you do hire a private attorney to help you out with this, either because we can't help you out or because you're not eligible for our program, then keep in mind that the Fair Debt Collection Practices Act, which is where all these rules come from, will require them to pay your attorney's fees if you're successful. Some other violations of the Fair Debt Collection Practices Act that you should be aware of. If you are sued for a debt, they can only sue you where you live when the lawsuit was filed or where you lived when you signed a written contract. So if they're suing you in a strange county, you should probably speak to an attorney about that. And then the very first time that company, that debt collector ever communicates with you, there are some specific rules of what they need to say to you. The biggest thing that they need to do is they need to tell you the amount of the debt that you owe. They need to tell you the name of the original creditor and the current creditor if they're different people. So if a debt buyer bought it, they have to tell you who originally owned it and who owns it now. They also have to give you a notice of the validation period. What this is you have a 30-day period where you can request that they provide evidence that you owe that debt and that they validate the debt with the creditor. So they should be giving you notice in that very first letter that they send you about that right. If they aren't doing any of these things, again, that's a violation of the Fair Debt Collection Practices Act, and you should speak to an attorney. Now, I'm not going to go through this in detail, but I do want to give you guys just a brief overview of what happens when you do get sued on a debt. So usually these are going to be filed in justice court, which is like our small claims court here in Texas. You're going to get served with the petition that actually talks about the debt. You have to file an answer within 14 days. And that's the most important thing. If you can take anything from this presentation, is if you get served with a lawsuit, whether it's a debt collection lawsuit or any other kind of lawsuit, you have to file an answer with the court. If you do not file an answer with the court, then they can get what's called a default judgment, which means that they're able to go to the judge while you're not there and show them the evidence that they have of the debt or whatever it may be, and finish the lawsuit without you ever being there. You can ask the court for something called discovery. That's basically asking for documents or information from the other side that you don't have. And then you're going to go to trial on it. If you're not happy with the result of the justice court trial, you can appeal by filing a notice of appeal within 21 days. And then if you do that, they'll open up a new case for you in county court. All justice court cases, you can appeal to county court, and all of those cases, as long as you file that notice on time, will get accepted for that appeal and we'll get a new case in county court. Typically, when you do appeal to county court, in a lot of cases, we see them move for something called summary judgment. That's them asking the court to look at the case in writing and determine that there's no need for a trial. If you have that happen, you have to respond to that motion for summary judgment no longer than 7 days before that hearing is set. And then you get what's called a trial de novo. That means a new trial. So you got that trial in JP court, you weren't happy with that result, you get a whole new trial up in county court where you can try again and see if the court will agree with you. Then, if you lose at the county court level, you can file what's called a motion for new trial. You have to do that within 30 days, and that's to ask the judge to reconsider. And if you want to appeal the case further, you have to file that notice of appeal within 30 days. Or if you filed a motion for new trial, you can actually wait 90 days to file that appeal. Then it goes up to the Court of Appeals. And then from there, if you appeal that decision, it's going to go up to the Supreme Court of Texas. So your case can go all the way from our small claims court and justice court to the Supreme Court of Texas if you want it to. Things are similar. I'm just going to go through this very quickly. Things are very similar if the case gets filed in county or district court to begin with. The biggest differences are that you have 20 days to respond instead of 14. But you still have to file that answer with the court. And then you have discovery, you have summary judgment, everything like we talked about before. And then you have your trial. And then from there, if you aren't happy with the result at county or district court, then you have to appeal to either the Court of Appeals or if that result doesn't go as you want, then to the Supreme Court of Texas. There's not that automatic right to go to the next higher court and get a new trial like you have in justice court. So you've gone to court, the other side has gotten a judgment against you, you've appealed it as far as you want to appeal it, and now they have a judgment against you. The question that you should be asking yourself, or that you might be asking yourself, is what property or money can they take from me now that they have that piece of paper from the court that says I owe $2,000? So exempt property and income, these are things that they cannot take from you. They cannot take Social Security from you. They can't take supplemental security income. They can't take veterans benefits, retirement benefits, public assistance or welfare benefits, workers' compensation, unemployment, court-ordered child support and spousal maintenance. That's money that you're paid in child support. In addition, in terms of the assets and property you own, you're entitled to your homestead, which has, and those are the acreage limits for your homestead, but pretty much in Texas, you can keep your actual home that you're living in, and they can't go after that unless it's a foreclosure. You can keep one vehicle for every licensed driver in the household. You can keep most all of your personal and household items. In terms of the enforcement of the judgment, it's valid for a 10-year period, but they can renew it past that 10 years to an additional 10-year period. And it will expire after that 10 years if they don't renew it. So they have that 10 years after they get a judgment where they can try and go after any property or income that's not on this list. Now, we do not have wage garnishment in Texas, so they can't go to your employer and ask for your employer to withhold wages to pay off your credit card debt. What they can do, however, is they can garnish your bank account for any income that was not on that list I gave you earlier of exempt income. So your employment income that's sitting in your bank account, they can take it by freezing your bank account and pulling it directly out of that. That does require a court order, but you won't have noticed that that hearing's happening. So you're not going to find that out until they've actually frozen your account and pulled the money out of it. So bankruptcy is an option that people definitely need to consider when you get sued for a debt, when you fall behind on a bunch of debts, or especially consider when you actually get a judgment against you. So there's two types of bankruptcy, Chapter 7 and Chapter 13. Chapter 7 bankruptcy is, the difference between these two is Chapter 7 bankruptcy is where they look at your assets, they figure out what's exempt and what's not exempt, they sell off the property that is not exempt, and they split that between all of your creditors. Now, for most people, you're not going to have any assets that fall outside of the exempt property list. So in a Chapter 7 bankruptcy, they'll often take no property from you and just forgive all of the debts at the conclusion of the bankruptcy. A Chapter 13 is a little bit different. The way a Chapter 13 bankruptcy works is they actually, it's called a reorganization bankruptcy. They actually set you up on a payment plan where you pay a monthly fee for a period of about 5 years. And at the conclusion of that 5 years, your debts are paid off. So there are two different things. One is focused on setting you up on an affordable repayment plan for all of your debts. And the Chapter 7 is focused on just forgiving those debts and selling off the property you have that you don't need. A bankruptcy, what does it do? It results in the forgiveness of your debt. So if you file a Chapter 7 bankruptcy, you don't have any assets, then all of your debts that you currently have, with very few exceptions, will be forgiven. The notable exception I want to talk about is student loans. For the most part, you cannot forgive federal student loans in a bankruptcy. You can still get credit after a bankruptcy. There are limitations to that. It depends from company to company, but it's not impossible for you to get credit cards soon after a bankruptcy and start to rebuild that credit score. After 7 to 10 years, in that time range, depending on the type of bankruptcy and some other factors, you're going to see that bankruptcy fall off your credit report, and then it's not going to be a factor for credit at all. So it's definitely possible to recover in terms of credit from a bankruptcy. When should you file bankruptcy? Well, you should file bankruptcy when you're in a position to change the things that caused you to fall behind on your debt. And what I mean by that is if you're unemployed and it causes you to fall behind on debt, you should not file bankruptcy until you have a new secure employment. And the reason for that is that you're just going to fall back into the same cycle and end up in debt again if you do it too soon. You can't repeatedly file bankruptcies. There's limits to how often you can file bankruptcy. So it's important that you don't file bankruptcy too quickly. It's also important that you don't file bankruptcy in situations where it's not necessary and where there's other better ways for you to recover from your debt. And I do get asked this quite a bit from people when I talk with them about bankruptcy. Is bankruptcy like stealing? And it's not. Bankruptcy is about giving people a second chance. It's about putting people in a position so that they can get a fresh start. It's nothing to feel ashamed about. A significant number of people do file bankruptcy. It's something to look at as a last resort option if you're in a position that you don't know how to recover from and you just owe too much money to too many people and you've gotten yourself in a rough situation. I want to talk specifically about the coronavirus pandemic and debt collection. So from April 9th to May 18th, the Supreme Court of Texas stopped default judgments and garnishments from being entered against people in the state of Texas for consumer debt. However, those have resumed. Those orders are no longer in effect and they can now get that. So everything is pretty much back to normal in terms of the courts in Texas. They can file lawsuits against you, they can continue on with those lawsuits, and they can get default judgments and garnishments against you now. One thing that they cannot do is that if they're garnishing your wages through a receiver or through a court-ordered garnishment, they cannot take money from you that is from a stimulus check. And you have a right to request a hearing to show what amounts of money they're taking from you might be from a stimulus check. And that's true through at least August 12th. Do keep in mind that right now courts are limited in what they're doing, so there might be limited hearings. Hearings might be held remotely. If you are in the middle of a debt collection case, you should be in touch with the court to find out how your hearing or your final trial will be held. You should keep that in mind. If you have a hearing date coming up, that it might be held remotely, either over the telephone or through a video conferencing software like Zoom. So that's something to keep in mind. I'm going to talk briefly next about credit reports. You have the right to a free credit report every year at a website called annualcreditreport.com. This is a site that's sanctioned by the government, and they're put in charge of the right you have under the Fair Credit Reporting Act to get a copy of your credit report every year. Now, this has actually been changed a little bit because of coronavirus. So first of all, Equifax was recently involved in a large class action lawsuit, and currently they're required to actually give you 6 free credit reports every year, and you can get those all through annualcreditreport.com. And currently, you're actually able to get each one of your credit reports every single week through April 2021 because of the coronavirus. They want people to be able to really monitor their credit. So at the moment, you can go every single week and check your credit report completely free at annualcreditreport.com. You can request it online on that website. That website also has forms that you can submit by mail, and it has phone numbers you can call to request your credit report over the phone. The quickest and easiest way is definitely requesting it online, but if you're more comfortable requesting it by mail, there are forms you can request to do that. What are your credit reports used for? A lot of stuff. They're used, of course, for credit cards, loans and mortgages, employment. Many employers have started checking people's credit before they hire them, so that's something to keep in mind. Housing, especially rental properties, Professional licensing, I had to do a credit check before I got licensed as an attorney. Many other professions do the same. Cell phones and utilities, if you've ever gotten charged a deposit before you're able to start an electric bill, it's probably because they checked your credit. And a lot more. Credit really gets used for tons of different things. So credit reports are very important. Even if you don't use credit cards, it's still something that impacts everybody's lives. So it's very important that you're monitoring your credit and keeping track of it. Now, questions to ask yourself when you're looking at a credit report. Do you know what everything on your credit report is? If there's unfamiliar accounts, where did those come from? You want to be watching for any instances of possible identity theft, so that's something to keep in mind. Are all of the dates accurate? Keep in mind that everything, especially negative information, has the date that it no longer appears on your credit report. So if those dates are inaccurate, it might stay on your credit report longer than it needs to. So that's an important thing to get fixed, even if it seems insignificant at the time. Is the balance accurate? That's an important thing to check, is whether they're reporting too much or too little on your balance, because it can have negative implications either way. Is the account correctly listed as open or closed? And this is an important one, is if the account is showing on your credit report as open, but you don't have the ability to actually use that, that's something that needs to be corrected. And the same is true on the opposite end. If it's reporting on your account as closed, but you're still using that card and it's still an open account, that needs to be corrected so that people don't think you closed the account. Does the same account appear on your credit report more than once? This could be a major indication of identity theft. If you have a Capital One account, maybe somebody else opened up a Capital One account in your name as well, and that's why you're seeing two accounts. It could also mean a debt buyer has purchased the account. Now, if that's the case, they should only be reporting one account, so you should speak with an attorney about that if it's appearing on your credit report multiple times. Now, if you're disputing a credit report because you did find some inaccurate information, the exact process for doing that's going to vary from company to company and credit reporting agency to credit reporting agency, but you can usually do it online through annualcreditreport.com when you check your credit report. The creditor will be given a chance to verify the information that they reported, so they get a chance to say, yeah, he does owe us this much money, it's accurate. And if they don't respond to your dispute, they don't provide that information to verify the debt, then whatever it is that you've reported as inaccurate will be removed. If they do respond, then it may either be removed or it might be left on the account or left on the credit report. So it just depends on what evidence they actually send back to the credit reporting agency. Now, keep in mind that these rules we've talked about with the Fair Credit Reporting Act, they don't just apply to the three major credit bureaus. They also apply to many employment and background checks. So when you go and apply for a job at McDonald's or Burger King or whatever it might be, and they run a background check against you, and they find all sorts of things about your history that may or may not be accurate, that is a credit report in many circumstances. And if there's inaccurate information on that background report, then you should speak to an attorney about disputing the information in that background check report. Because, if that's costing you employment, that's something that's going to follow you until it gets resolved. So it's very important to take that seriously. And I will say, for employment background checks and other types of credit reports, you have a right to a copy of all of these if an adverse action is taken against you. So that means if you apply for a job and because of a background check report that's considered a credit report, they didn't give you the job, then you're entitled to a free copy of that report. Housing background checks, same thing. Many rental properties will run a background check that includes your rental history. So if they're seeing an eviction that never actually occurred, that's something you need to get fixed. Specialized credit reporting agencies, there's hundreds of very, very specialized credit reporting agencies out there. So any sort of background check report or credit report that somebody refers to, all of these same rules are going to apply as long as they meet certain criteria that makes it a credit report. And like I said before, you have the right to a free copy of these reports if you're denied any benefit because of the information contained in them. And that's true even if the information is accurate. You can get a free copy of that if any action was taken against you. And that doesn't necessarily mean you are denied housing or denied employment, but if you're not getting paid as much in the job, or if you're paying more for your rent or more in fees or more for a deposit because of the information in your credit report, then you're entitled to that free copy of that background check report as well. And if you were denied anything or you're paying more for it because of incorrect information after you request that free copy of that background check report, you should speak with an attorney about that so that they can help you correct that background check report and possibly get damages from that company for reporting that wrong information about you. And I want to talk a little bit about coronavirus specifically and how it impacts you as a consumer. So first of all, the big topic, of course, with consumers right now are the economic impact payments or stimulus checks. So some people don't know whether or not they're actually eligible for a stimulus check, so they don't know whether they should be expecting one. You're eligible for a stimulus check if you make under $99,000 if you're single or if you're married filing separately in the last tax years, under $136,500 for head of household filers, and under $198,000 per year if you're married filing jointly. Also, you cannot be claimed as a dependent on someone else's tax return. You have to have a valid Social Security number, and you cannot be a non-resident alien. The amount of the stimulus payment will be $1,200 for individuals, $2,400 for a married couple, and an additional $500 per dependent child. This amount's going to be reduced if you make over $75,000 for individuals or over $150,000 for couples. So how will you get that stimulus check? Well, first of all, if you filed taxes in either 2019 or 2018, you're probably going to be getting the stimulus check or that economic impact payment the same way that you got your tax return. So if you received your last tax refund by direct deposit, you're going to get it by direct deposit. If you received it by mail, you're going to get it by check or a prepaid debit card. If you did not receive a tax refund, so you owed taxes to the government, then you're probably going to get it by either check or a prepaid debit card. If you've not filed taxes in both 2019 and 2018, so this would be 2019 and 2020 is when you're actually filing it, but it's for the 2018 and 2019 tax years. If you haven't filed the taxes in either of those years, then if you receive Social Security or VA benefits, you're going to get your stimulus payment the same way you get your Social Security. And if you do not receive Social Security, then you have to file online, and I'll give you that website in a second. But you have to file online basically a very abbreviated tax form for 2019 that tells them that you don't make enough money in the year to be required to file taxes. But you can still get a stimulus check if you fill out that online form. If you haven't filed your taxes and you are not on Social Security, then this is the link you're going to want to go to. It's irs.gov/coronavirus/non-filers-enter-payment-info-here. You can also just search online for non-filers enter payment info here, and that should pull that right up. But you're going to want to make sure you're on the IRS website, and that has all the instructions and information you need to fill out the form and get your economic impact payment by direct deposit. They are sending people stimulus payments if you haven't gotten one yet. by prepaid debit card, and that's very important to know. It's important because it's coming in a plain envelope from a company called Money Network Cardhold Services, which is the company that the government has contracted with to issue these debit cards. Now, the reason I want to emphasize this for a second is because this mailing looks like every credit card offer that you get in the mail on a daily basis, and many, many people have mistakenly thrown away their economic impact payment for thousands of dollars because they thought it was junk mail. So it's very, very important that you're looking for a plain white envelope from Money Network Cardhold Services, and you don't throw it away. When you open it, this is what the card should look like. So you should have a debit card like this. It will have your name on it, and you can use this like a debit card. I'm also going to talk about some ways that you can pull that money out of that debit card and transfer it over to your bank account or use it in cash. So to avoid fees, there are fees on those prepaid debit cards. So here's some ways that you can get that money off of your prepaid debit card without paying any fees. First of all, you can just use that like a prepaid Visa card. Go to Walmart and buy some groceries with it and use that as your payment method. You can also withdraw the cash at a surcharge-free all-point ATM. Those are the only ATMs that will not result in a fee. They have those in many grocery stores, but you're going to want to make sure it does not list the fee and it is from Allpoint. You can transfer the money online through the EIP card website. That information will be in that letter that accompanies that card when you receive it. They also have a mobile app you can use to transfer the money for free to your bank account. You can also just take that card to your bank or your credit union and ask them to withdraw the money for you. Or this is a slower method, but you can also do it this way. You can call this phone number, 800-240-8100, and request that they mail you a check. And then you can use that check just as you would any other check and take it to your bank and deposit it or take it to a place to cash. You can track your stimulus payment by going to irs.gov/coronavirus/getmypayment. Again, you can just search IRS Get My Payment and it should come up. If you have a lost or stolen prepaid debit card from this program, so if you think you may have thrown it away, you can call 1-800-240-8100 and they will issue you a new card. The first one is free, but subsequent cards, they do have a fee for, I believe it's $7.50. So just keep that in mind that if you lose it more than once, you will have to pay a fee to get that card reissued. If you believe your stimulus check has been stolen from you, number one, I always recommend contacting an attorney if you believe that your identity has been stolen. But I also recommend that you go to identitytheft.gov. They have already loaded the information about the stimulus into the identitytheft.gov website. It'll walk you through an interview online, and it will populate all the forms you need to submit both to them and to the IRS to report to the government that your economic impact payment or your stimulus check was stolen. Some other stuff that's relevant right now during coronavirus is the federal student loan relief that's been granted as part of the CARES Act by the federal government. So remember, we're talking only about federal student loans right now. So if you have a student loan through a private bank like Discover, it is not going to qualify for this relief. Also keep in mind that most student loans that are issued by the federal government are serviced by a private company. So you might have a company called FedLoan or Great Lakes Servicing or Mohila. All of those are private companies that the government contracts with to service their loans, but it is still a federal loan. If you have a federal loan, you do not have to make a payment for a 6-month period. That's March 13th until September 30th. If you are on auto pay, your servicer should have turned off auto pay and should have stopped taking payments from you. You will have 0% interest during that time period. You will have no negative credit impact from any of this, even if you don't make those payments for that 6-month period. Though you should watch your credit report for your student loan being reported as being in administrative forbearance or deferment. At least one company, Great Lakes, has been reported as accidentally listing all of the student loans as being in forbearance or deferment, which does have a negative credit impact. So if you look at your credit report and your federal student loan is listed as being in forbearance or deferment right now, you should speak to an attorney about that. There is a class action pending against Great Lakes, but if you see that with any other servicer, you really do need to speak with an attorney because that can be negatively impacting your credit right now. You can request a refund for any payments you made after March 13th. So I can say personally, my auto pay was on like March 15th for my student loans. So I contacted my servicer and I've requested a refund for that March 15th payment because I'm entitled to have that money given back to me since they backdated that relief from March 13th to September 30th. If you decide to voluntarily make a payment, you can get that money back if you ask your servicer for a refund of that payment you made during this time period. And during this time period, if you're on an income-based repayment plan, or if you work for a nonprofit or the federal government or state government, and you're eligible for what's called public student loan forgiveness, they're supposed to continue to give you credit during this 6-month period like you've been making payments every month. So I work for a nonprofit organization at Legal Aid. So I work both towards income-based repayment and public student loan forgiveness. Those are two different forgiveness programs based on making timely payments for a certain amount of time. I'm going to get credit for all 6 of these months as if I had made my payment on time, even though I don't actually have to pay anything. I want to talk briefly, we're nearing the last 20 minutes and the end of our conversation today, but I do want to talk briefly about fraud before I leave, because it's a very important subject that we all need to be aware of. So the first thing to keep in mind is what fraud actually is. A fraud is an intentional act to deceive somebody for personal or financial gain. So it's lying to somebody so that you get some benefit from it. Now, 3 concepts kind of get confused a lot, and it's very important that you know the difference between these, and that's fraud, breach of contract, and theft. Breach of contract happens when 2 parties enter into an agreement and one just doesn't live up to their obligations. Fraud happens when someone intentionally lies to the other person to get them to enter into that contract or to do something that they wouldn't have done if they had known the truth. And theft occurs when one party does take something of value from you without your permission. So what does this look like? Well, in a breach of contract situation, this might mean something like you paid money to a contractor and they don't show up because the employee that was going to do the work for you quit their job the day before, and they no longer have the resources to take on your contracting job. Fraud, on the other hand, is if you paid money to a contractor and they didn't show up because they never actually had an employee capable of doing the work and they never were going to show up. They got you to enter into that contract and give them some money because they lied to you about the fact that they were going to come. And theft is where they take money from you that you actually didn't want to give them. So if they did a job for you, you gave them your credit card, and you authorized them to charge you $1,200, and they ran it in their credit card reader as a $3,000 charge, that's theft. So in terms of spotting fraud and bad transactions that might lead to fraud, here's some risk factors to look at. The number one is just offers that sound too good to be true. This is cars priced well below like the Kelley Blue Book value, contractors promising that they can work with your insurance company and somehow make it so that they can do the work for free without you paying the deductible. This is very common, where a storm or tornado has just happened. They'll come door to door and say, hey, we'll fix your roof damage for you. We'll work with the insurance company and we won't charge you a thing. We'll be able to do it so you don't pay a deductible. What they're doing is they're lying to the insurance company in your name about how much the job cost and how much money you gave them. So if it's a $2,000 job and you're supposed to pay the first $500, they're going to tell the insurance company it was a $2,500 job so that they billed $2,000 to the insurance company and nothing to you. And what they're doing is they're committing a crime of fraud on the insurance company in your name, and you could be held responsible for them doing that. Companies that promise timeframes that differ significantly from any other company. If a company calls you and says, oh, we can get this house built for you in 2 weeks, and every other company you call is a 6-month job, then you know something isn't right. They don't even know what they're talking about. They don't have the right time frame, so it doesn't make sense. Companies that come to you, cold calls, door-to-door salesmen, really nothing great comes from those situations. For the most part, if somebody comes to your door and tries to sell you a service like contracting or roof repair, you're probably better off finding your own company rather than going with the door-to-door salesman. Do some online searches of the company that you're looking at hiring. Do they have very few reviews online? Do they have negative reviews? Also, do they have suspiciously positive reviews? Many companies will write reviews of themselves. So if you go on a website and they have 100 absolutely perfect reviews that all seem very canned and not specific, that might be an indication that you're not dealing with a real company. You want to look at the dates of those reviews and make sure that they didn't just pop up 2 weeks ago and all of a sudden there's 200 reviews of that company, because that doesn't make any sense that they would get that many that quickly and have no other history. If they don't have a website, it could mean nothing. It could mean it's a small company, but it could be a sign of fraud as well. So look out for that. Checking court records is a great one. In Wise County and in Denton County, you can check court records for free. That's a great way to see if this is a company that's gotten sued many, many times. Here's the websites for that. You can check court records in Wise County at jail.co.wise.texas.us. And you can check court records in Denton County at justice1.dentoncounty.com. Those are great resources to be able to see if a company has a big history of getting sued for bad work. Also look out for any weird factors about the deal. Unusual payment methods. You've always heard of people asking over the phone to get paid in a gift card. That's a major red flag. Wiring money. Very few legitimate companies want you to ever wire money to them. So that's a red flag as well. If they overpay you in a money order and they ask you to send back a portion of it, it is 100% a scam. That's a very old scam where they're supposed to send you $500 for some reason. They send you $1,000 and they say, oh, we sent you too much. Send us $500 back. That check will appear to clear with your bank, and then in a week or two, they'll find out it's not a real check, and they'll take that money back out of your account. Paying someone other than who you did business with. So if they say, don't pay us, I want you to pay John Smith for this contracting work, that's going to be a major red flag as well. And if they don't have a physical business location, again, it could be a legitimate business. Many people run small businesses out of their home, but if they don't have a physical location they'll share with you, you might want to do business with a large company. If they won't send you agreements in writing, don't do business with them. That's pretty much always going to be my advice, is if a company refuses to do business in a way that you can get a written agreement, then look elsewhere for a company to do business with. Some other tips: shop around. If you feel like you have to agree to something immediately, there's probably concern that it's a bad transaction. If you've ever watched the show Shark Tank, they'll do that sometimes, where one of the investors will say, you need to give me an answer right now. If you ask anybody else, then I'm withdrawing my offer. That's probably a sign when you're dealing with companies that you should look elsewhere, because any reputable company wants you to shop around and wants you to see that they offer you the best value. Ask a friend or a coworker. Ask them either for recommendations about who to work with. You can also just tell them the situation and get their perspective on whether it seems too good to be true or whether it seems fraudulent. Sometimes people have dealt with similar situations. They might also just recognize a scam that you don't. So it's always a good idea just to talk to another person and get some advice. Ask questions. So businesses should be happy to answer questions about the service or product they're offering. They should also be experts in that field. So if you're buying a car from someone and it's a dealership, they should be able to answer all sorts of questions about cars. That's not to say to give them a quiz show in the middle of the dealership, but they should be able to give you very detailed, specific answers to questions about the vehicle you want to purchase. So don't be afraid to ask them questions. And then I'm going to talk very briefly in these last couple minutes about auto history. Here's some links where you can check the auto history of a vehicle. These are all, for the most part, paid checks. There's Carfax and AutoCheck are the two major private companies that offer vehicle background or vehicle history searches. There's also vehiclehistory.gov, which is a listing of different government, different companies that provide a government-sponsored search. Those have a fee as well. There are two free searches you can run. nicb.org/VINCheck. This is a search of a national stolen vehicle and impounded vehicle, salvage vehicle database. And then there's another private website called salvagedb.com. This is recommended by the state of Texas. This is just a website that searches online for listings for salvage vehicles. So you can often find a vehicle's record in there if it's been sold at an auto auction. And also this last note I had of presence of records versus absence of records. Just keep in mind that these are not perfect sources. So if something is on the record, it probably is accurate. But if there isn't a record, that doesn't necessarily mean that it doesn't exist. So if there's an accident on your Carfax report, it probably means the car was in an accident. But just because there's no accidents reported on the Carfax doesn't necessarily mean that car has never had an accident. There could be an accident that didn't go through insurance, so it didn't get reported to Carfax. So that's something to keep in mind. When you're looking at your auto history report before you buy a vehicle, you're going to want to look for any inconsistencies, the color not matching the car and how it is now, damage on the car not matching the report. If there's a dent in the front fender, you want to know, or the front bumper, you want to know where did that come from. So if there's no accidents reported, you're going to want to find that out. The mileage not adding up. The ownership history, if they say it's a one-owner vehicle, make sure that auto history report agrees and that it's only been owned by one person. And then auction history and salvage history are very important. You want to know whether that car has been in a major wreck and has been completely salvaged out. And always ask to see the physical title before you buy a vehicle, especially if you're buying from a private party. You want to make sure that's not a salvage title and that they actually have the title of the vehicle. If you're buying from a dealer, they should have a buyer's guide on the window of the vehicle when you go to the lot to see it, and it should mark what type of a warranty and whether it's an as-is sale. So keep that in mind. If they don't have this listed, it is a violation of federal law, and you can possibly file a lawsuit against them. Some final resources. These are some agencies which you can go to file complaints over any sort of consumer problem you're having. For insurance problems, go to the Texas Department of Insurance. For creditors and debt collectors, you can report them to the Federal Trade Commission, the FTC, or the Consumer Finance Protection Bureau, the CFPB. For car dealerships, you're going to want to report them to the Texas Department of Motor Vehicles. And for all businesses, you can report them to the Texas Attorney General for any sort of fraud. For more information about the stimulus, I would say go to irs.gov/coronavirus. That's also going to have those links, those various resources and websites we've talked about earlier in the presentation about the stimulus checks. For identity theft, go to identitytheft.gov. It's a great resource for any type of identity theft, not just stimulus checks. They give you a lot of information about how to recover from identity theft, and they help you fill out all the forms you need to report that to the federal government. And for more resources about coronavirus on consumer issues and non-consumer issues, you can go to www.landwit.org/COVID-19. And I just want to thank everybody for watching this presentation, whether you're watching it in the live stream or you're watching it after the fact on the recorded version of it. I want to thank you so much for taking the time to listen to this advice. I hope that you've learned something that you didn't know before about being a consumer in Texas. And if anybody does need help with a legal matter and wishes to have Legal Aid of Northwest Texas represent you in that, you can apply for services, like Emily said earlier, online or by phone or at your local office. If you wish to apply online, you can apply at www.landwit.org. You can apply by phone at 1-888-529-5277. You can also find your local office. If you're in Wise County, which many of you are, since this is so graciously hosted by the Decatur Public Library, you are probably within the service area of my office, the Denton office. We're located at 2220 San Jacinto Boulevard, Suite 205 in Denton, Texas. Like Emily said earlier, we are currently closed to the public, but we're still operating. So you can give us a call directly at 940-383-1406, and we'll get in touch with you about taking your application as well. So there's lots of different ways to apply for services with us, however you wish to do it. We definitely would love to hear from you if you're having an issue and you believe you're eligible for our services. Like I said earlier, you can get more resources about coronavirus online on our website. And we'd love to hear from you if you have any other questions or concerns. But other than that, I think that's it from me. Let me check and see if there were any questions from the chat. All right. Well, it doesn't look like we have any questions. So I believe that's going to be it for tonight. But I do want to thank you all so much for coming. And if you are watching this in the recorded version or the live version and you do have questions come up, feel free to give our organization a call. And we would be happy to take an application from you so that we can look at your legal matter and see whether we can answer those questions and help you out. Thank you again.